Hi there, my name is Rafael Lazaro. I am the owner of Lazaro Law Group, an employment law firm based in Chicago, Illinois. Today I want to talk to you about a pressing question that our employee clients have when they pick up the phone and call our office. And that is, do I have a case? Should I pursue this against my employer? Well, today I'm going to walk you through a few things to think about whenever you are considering whether to move forward with some kind of lawsuit or some kind of demand letter against your employer. The first thing to know is that most, if not all jurisdictions, except Puerto Rico for sure, they have the at-will rule. That means that in all jurisdictions, the employer can fire an employee for any reason whatsoever, and that is not illegal, except if you have a contract of employment, obviously, and except a few reasons that are identified in the law, like the Age Discrimination in Employment Act or Title VII, and those reasons are the famous protected categories like race, color, religion, age, national origin, sexual orientation, etc., etc. So why is that important? Because a lot of employees come to us rightly feeling that they've been mistreated or abused by their employees, and sometimes if that abuse or mistreatment is not linked to a protected category, then that action is not necessarily illegal. So the first question to ask yourself whenever considering whether you have a case is the act taken against me, be it your termination, suspension, or whatever else, linked to a protected category? If the answer is yes, you might have a case. If the answer is no, you may not. So that is the first thing. The second thing to consider is, what evidence do I have? That's the second thing, because many in the work that we do, it's not really about what happened, it's about what you can prove. There are two things that I look for immediately. Number one, has your employer, the particular supervisor, mistreated others that are in your same protected category? Meaning if you are suspecting that the actions are taken against you because of your age, has that person mistreated other people that are older workers like you, for example, or a particular race or national origin? And are those people willing to talk to a lawyer? So that's number one. Number two, are there any witnesses to what happened? And number three, what documents, videos, or other evidence do you have to prove that the particular action is linked to your protected category? So that's issue number two to think about. So issue number three to think about is, what are your damages? Normally, damages in employment discrimination cases are linked to the amount of salary or the amount of money that the employee failed to make because of the discrimination and harassment. And there is an obligation to mitigate damages. And sometimes you could have a great case, be it of sexual harassment or any other type of discrimination, but the employee is a good employee and they went out and went to the marketplace and they found 2 weeks later a better position that pays them more. That means that the employee is not going to have those types of damages, right? But they might have emotional distress damages, for example. But if you did not lose salaries or benefits, it is harder for a lawyer to say yes to a case and prosecute your case. So those are the three things to think about. Number one, is my employee issue linked to a protected category? Number two, what evidence do I have to show that it's linked to a protected category? And number three, what damages can I go after? So that's it. Those are my three tips or my three things to think about when you are if you have been terminated and trying to figure out whether you should go to a lawyer take the issue through the administrative or legal process. That's it for this week. I hope you enjoyed it. See you later, everybody. Bye-bye.